We are going to start, sir. We are going to start in a minute. Okay. We are starting right now. Okay. Thank you. So good morning, all of you, and we welcome you all this most awaited session in the new year, and wishing a very happy new year to one and all, like who have joined in this session. And last time, from last 2 months, like many people are requesting for the a DPDP Act. So that is the reason like we have requested Madam to join with us today. So it is good that like Madam has agreed and she joined with us today to elaborate more on like what is the DPDP Act rules and how applicable to all of us kind of thing, right? So with that thing, like we have done this. So I request Sir Ma'am, like don't give any emojis and all at this point of time. Let's move on the session. Later we will see. Okay, by end of the session kind of thing. So once again, good morning and welcome you all on this data privacy in the digital era. So an overview of DPDP Act and compliance rules kind of thing. So as you all know, like we were observing the Cyber Jagrata Divas on first Wednesday of every month. As per the instructions from the Ministry of Electronics and Information Technology, Government of India. So our Ministry of Home Affairs has referred to organize these kind of Cyber Jagrata Divas on first Wednesday of every month. So still we are following and we are organizing on various awareness session. The objective of this CZD is to create awareness on prevention of cyber crimes through or in the form of awareness workshops, seminars, and interactive sessions, quiz competitions, best practices, and all. Like we are organizing n number of awareness workshops, first Wednesday of every month, as well as other days also on Fridays and all. And we are also organizing quiz competitions and all through our Stay Safe Online web portal. And every time like we are sharing our best practices as well as case studies to enable the people and follow the cyber hygiene practices. And we're also highlighting the cyber hygiene practices as part of the professional and personal life. So our by end of the day, like what of the session we are dealing, all the sessions we are focusing on like whatever the best cyber hygiene practices someone should follow as part of their professional as well as personal life. So that is what we wanted, and we wanted all the people to be safe on the cyberspace in spite of a lot of awareness was got created from the highest level of the country to grassroots level. It is unfortunate that like many people are facing many issues like in terms of either the digital arrest and all such kind of things. Like whatever you are learning, at least you spread this awareness within your family, within your organization, with your family friends kind of thing, right? So then only we can stop that. Otherwise many of the people are falling prey for such kind of issues. Okay, so that's the kind of thing. So these sessions we were doing all the employees of MIT and other ministries and departments, and under organizations of MIT also. And like from not only from this session, like as a whole, like we were discussing on like what was the social engineering attacks and password security, multi-factor authentication, all those aspects, social media, privacy and security settings, and digital financial transactions and all we are targeting. So these sessions are organized under the aegis of Information Security Education and Awareness, which is the Ministry of Electronics and Information Technology, Government of India project, right? So in this, like we have 4 important key verticals: generating highly skilled certified cybersecurity professionals, and grooming the students towards the product and solutions in the development of cybersecurity. And we're also focusing on the strengthening the research and education. So right now that innovation hackathon was on, and we are getting good number of entries. And if any of you people are interested, you can participate in that. Your school, your college, our institutions. If you want to participate, they can participate in that. Hackathon. So people can exhibit like what kind of things they are facing at the same time. Like you can visit that hackathon, our ISEA.app page for more information. And we're also doing this cyber aware digital cyber aware digital nagriks, which is a mass awareness program. And to facilitate these 1 to 4, like we have a common infrastructure like Indogenius. Like we have created forms, assessments, quizzes, and capture the flag and all such kind of activities. And as we told, like we were doing all these programs under banner of ISEA, Cyber Aware Digital Nagrik, which is a stay safe online portal which we are talking about. So to create awareness among the various group of users, we were doing these awareness workshops, webinars, and we're also closely working with the state police department for awareness weeks, ARDD community radio and all. And we're also using this educational TVs, and a mobile app is there. So we request all of you, please download that ISA app, and you'll get the alerts, and there are some educational games which you can enrich your knowledge by playing those or by following those games kind of thing. And multilingual awareness content, we have a website which I'm going to show it to you, handbooks, posters, all those things we kept it as part of the portal. And we're also, most of the people or most of the scenarios, people will organize 1 hour 2 hour session and they will leave it there. But we wanted you to continue the cyber education by enrolling yourself any of these courses. Like if they are students like cyber kid, and if you are 15-16 years old and up to 23, cyber cadet, and you have cyber yuva. And if you are a teacher or a faculty, cyber shikshak. If you are an employee course, all those kind of courses we are offering, so that you can enrich your knowledge and you can be safeguard yourself in the cyberspace. And we are also doing these competitions. National level competitions are on right now, and the last date for submission of these competitions are 15th of January. And we're also organizing these quizzes regularly. And now we were requesting all schools and colleges to start cyber clubs to proliferate this cyber safety and security awareness among the students, teachers, and parent groups or community kind of thing. And good number of cyber clubs were established across the states and across the good number of schools in India, right? So these are the various awareness activities which we are doing under the Cyber Aware Digital Nagrik Mass Awareness Program. And this is the portal which I'm talking about. I think most of the people are aware, and if you are unaware, please visit this portal for different awareness resources. Awareness poster, cartoon storyboards for kids and students, for them to understand easily. And we're also coming up with warning signs and some kind of cyber alerts, brochures, handbooks, and concept videos. And if you want to learn some concept, you'll be having concept videos, and you will be having a lot of content. So those two things, it will help you to understand and follow those cyber hygiene practices as part of your professional and personal life. So these are the various fitness assessments which we have kept it for you, and you can enroll and you can check your fitness up to what extent you are there, and what else you can learn. For example, email safety and internet usage at workplace kind of thing. So that is the thing. So you can check your knowledge on the particular topic, and check your knowledge, and you can enhance your skills further in this regard. And these are the courses which I'm talking about. So these courses are available under Stay Safe Online. You just bring it down so that you will be having different courses for different people, and you can ask your children, family members, and your colleagues to enroll and go through these kind of courses. And most of them are video based content is there. Assessment is there on every topic, and final assessment is there. Instantly, you can download your certificate also once if you are completed the course kind of thing, right? So these are the various courses which are offering. So all these courses are available in staysafeonline.in portal, right? And this is the thing, like we wanted to enhance our spread across the country. So we have opened for an individual as well as organizations to join with this momentum to create the cyber awareness among the various group of users. So we have come up with the cyber ambassador program. So you can enroll yourself into the cyber ambassador program, and you can complete the cyber defender program. Later part, like we will interact with you, and once you are satisfied all those things, then you can start your activities. Okay, that we have corrected, sir. Right. So to deal with today's session, we have with us Dr. Karinika Seth, madam, and she is a cyber lawyer at Supreme Court of India, and she is also an arbitrator, author, policymaker, and educator. And she is a founder of Seth Associates Law Firm, and which is located at Noida. And she is a country chair for G100 Mission Million, which deals with AI, data, and cyber security. And Dr. Seth is internationally renowned cyber lawyer and IP and media law expert practicing in the Supreme Court of India the more than 25 plus years. And she acts as a legal advisor to the Ministry of Electronics and Information Technology, Government of India, and actively contributes her expertise in various national projects. She is the appointed country chair cybersecurity for G100 and a global group of women thought leaders. And she is an accomplished arbitrator, author, and a policymaker, and a highly inspiring speaker in the conferences, print and electronic media, and television. And Dr. Seth is also founder of the Seth Associates, an established law firm based in Delhi that renders the legal services to both domestic and global clients. So, with these vast experience, we request Madam to take this session on data privacy in the digital era, which is an overview of the DPDP Act and compliance rules. So, with this brief introduction, we request Madam to take over the session. Thank you, Ma'am, for joining with
Thank you,
us.
Jagdish, for this important topic that you've kept for today. And at the outset, namaskar to everyone who joined us today, and Happy New Year to you. I know this subject is such that everyone would be interested to know what is the DPDP ecosystem, which we are trying to, put it across in India. How will it work? So I'm glad that this session on ISEA will be yet another empowerment contribution to knowledge sharing and basically explaining the nuances of this new law. So with this, I want to start with sharing a presentation. If you allow me a share screen, I will just like to do that.
Yes, Ma'am. It was shared, Ma'am. It was shared, Ma'am.
Yes. Are you able to see the screen?
Yes, Ma'am. Yes, Ma'am. It is coming.
Right.
Yes, Ma'am. It has
Right.
come. Thank you.
So, as you all know, that today's topic is data privacy in the digital era. Now, in today's times, when we talk about data, we all understand it's the new oil, as we use this term so much that personal privacy or data privacy is intertwined today. So, in very simplistic terms, I will like to explain how we have understood this law and how it will need to be implemented in India, and how businesses, including private businesses or even government work, and in terms of handling of the data, personal data of citizens, will be impacted, and how positively we are shifting to respect our fundamental rights of citizens to preserve their privacy in the legal parlance in the cyberspace. So let us see what this data privacy really entails in today's times. Now, why did we really need data privacy? Right from the time when you know in the Supreme Court, we've handled very many cases on data privacy, and today we are even talking about right to be forgotten. We've come a long way. I would say that from the times when only physical surveillance was the topic of discussion in certain cases, and initially, and now the focus has shifted to data privacy, because we are more and more transacting online. We are using online for various purposes, and our personal data, including health records, including any kind of biometrical information, passwords, financial data, could be at risk. And that's the reason of focus has been shifted to data privacy. At the outset, when we talk about the DPDP law, this is pertaining to digitized data only. So I want to clarify at the outset that if you're collecting information in hard copy, for example, pen and paper mode, then unless that data gets digitized, this law will not apply. So when we understand data here, it will be personal data. It will be something which identifies a person also, which will be covered. For example, it would be the email address of a person, or it could be a telephone number, which would be an identifiable factor. So this is the scope in terms of the scope. We are talking about personal data, and we are talking about digitized data alone. Now let's have a look at the fundamental aspect that currently we are using 43A. For example, we were using 43A of the IT Act and Information Technology Rules of SPDI till this law came into operation. So now this DPDP law repeals this section 43A and these SPDI rules. The core concept, talking about the core concept, I have just mentioned what digital personal data includes, but looking at the jurisdictional principle, it is important for us to understand that any data of Indians, whether we are dealing with the processing and collection of data processing within India or outside India. So supposingly there are foreign offices working on processing Indians data of Indian citizens, even this law applies in that situation. So it is something which is cross border. You can even say that Indians' data should be involved. I'm just drawing an analogy with GDPR, for example, in Europe, where any data of European citizens, whether processed within European Union or outside, would be covered by the GDPR law. Likewise, we have it in India, the DPDP law would be covering this whole scope. Now, an important rider that this law DPDP doesn't apply to certain categories of data. For example, there could be data which is anonymized where you can't identify a particular person from that data, and it could also be something which has been used in a way that it has been delinked from the individual's identity. So it could be just a statistical data. In that respect, this law doesn't apply in that regard. Now let's look at the applicability once more, that this law doesn't apply where processing of personal data is for domestic purpose or for your personal purpose by the individuals themselves, and it equally applies in the case of government as well as private bodies that we also understand. Now, whether these activities are concerned with providing services to data principals within India is an important factor. So, if any Indian citizens are deriving products or services and giving away their personal data for the same, this law covers their security of information. Key terminologies, we are very familiar with now most of the terms, but on a very snapshot basis, fiduciary is a person who's collecting the information. For example, a website which collects information of the individual. A processor will process it, maybe even store that information on behalf of the fiduciary. It could also be now a data principal. In this whole ecosystem, a data principal would be the user, the person who's giving away his personal data for availing a service, for example. Consent is a very, very important aspect of the whole scenario, because without consent, there are very few exceptions where consent may not be required. And this consent of the user has to be express, clear, freely given, and specific. It has to be unambiguous. And a consent manager could be involved to facilitate this giving of consent and updating a particular person's record, who would be an independent body now as per the DPDP law and the rules. Now, these are main terms which we very often use in this law, but consent, as I said, may not be required in certain situations. For example, if there's a threat to the nation, or if there is, something which is like a flood scenario or a disaster, and for managing that or providing any medical aid to a particular person in that situation, consent is becoming it becomes redundant, so it's really not necessary at that particular point of time. The law provides for these kind of situations very justifiably. So looking at the grounds for processing personal data can only be processed for a lawful purpose. So first of all, it has to be lawful, the purpose, and either be with consent or for a legitimate use. Now, legitimate use could be one of those aspects which I just mentioned, and we will delve more on it. But it could also be something which is, when you're trying to enforce a law, or you're trying to enforce a judgment in a particular given case, then obviously you don't need a consent in that scenario. And there are many other situations which we'll be covering in the further slides in this presentation. So, a lawful purpose would be any purpose which is not expressly prohibited by law. And at the time when requesting consent, this fiduciary has to provide a notice. So, what essentially will happen is, for example, when you're downloading an app, there are terms and conditions there. There are privacy policies there. They will have to give a notice to explain what is the data we are collecting, what is the process which will be involved, and what will be the purpose, how this data would be used, and if there is rights, there are rights of data principles, what are those rights, and how one can file a complaint with the board in case those are not, grievances are not addressed. So these are some basic things which have to go in that notice. Notice essentially will be like a terms of use or a privacy policy which is on the website or an app. Now, coming back to consent, it's important to have this in, it's say, an English language, and also maybe in a language which is from the eighth schedule of the Constitution, a local language. So that's something which is required by the law. And the consent managers, they are accountable. So when we say accountable, they will directly coordinate with the data principals and manage their consent requirements. They have to be registered with the data protection board. So there are certain norms who would be a consent manager, which are dealt with separately under a schedule of the DPDP rules. We'll be coming to that as well. Now, so far so good. Look at the obligations of data fiduciaries. Now, what does a data fiduciary need to do? So, in order to fulfill its obligations, it has to engage, when it's engaging with, say, a data processor, it is engaging a particular company to safeguard its information. It's using a VPN provider, or if it's using a server or hosting company, they have to adhere to the same norms of data privacy as the data fiduciary, and that is the responsibility of data fiduciary. So here we step in as legal experts. What we do is we look at the lacuna in their agreements. So increasingly what's happening, whether it's a government department or it is a private institution or an organization, right from looking at their notice requirements, whether they are fulfilled, the DPDP requirements are fulfilled by that. Then we look at the terms and conditions, the privacy policy, and then comes the aspect of agreements which they are having with their service providers, in terms like servers, for example, whether they are fulfilling the norms of DPDP. So if not, then we legally vet that document to make it airtight. So this is very important, because a lot of departments now and also private institutions are looking at overhauling their whole way in which the not only the operations of a particular entity were conducted, that is to be balanced with their own internal set of rules and regulations, and how they are handling the information. So including the not only the templates of legal templates, but also the operations, how they are conducted. For example, they have to be encrypted. Certain data has to be encrypted. So that's something which they are infusing new processes. They are infusing new tools and technologies to protect that data, which is very essential requirement. So what we're doing is we are going in phases: phase one, phase two, phase three, because this law which has come about is 18 months period has been given, and different provisions come into being on a different stage. But we'll be discussing those stages as well. But so far, this is important to highlight that the already for preparedness of DPDP phase one work is already in motion. Now, this law also requires data retention requirements, so the data has to be erased after the lawful purposes has been met with. If an entity requires more time to manage the data for research, for example, or any kind of survey, then that has to go in the notice. If it doesn't say so, they cannot retain data more than necessary. Also, the fact is that there may be sectoral laws and norms that will have to be met with. And so one has to be mindful that not only DPDP compliance is essential, but this law says that sectoral laws, other laws will also equally apply. So one has to be mindful of what timelines exist in the terms of retaining data as well. The data has to be complete, accurate, and consistent. So the way in which data principal can upgrade, any data, for example, a new mobile number, a new email ID, that has to be managed directly with the data fiduciary or through the consent manager. Any children's data collected, which is data of below 18 years of usage, then the minors, they have to only go through a parental verifiable parental consent. Unless this is achieved, children's data cannot be taken in India. Now comes the disclosures. For example, the disclosures, one looks at the details of other data fiduciaries, who that data fiduciary is sharing information with, can also be asked by a data principal through a written request. Any breaches of this data have to be reported to the data protection board. And it's very clear that certain new additional requirements have to be met with for case of significant data fiduciaries. Who are these has yet to be identified and declared by the government, but these significant data fiduciaries have clearly an additional role of creating an audit and having an independent data auditor and having data impact assessments, because they deal with volumes of data. So therefore, the risk is higher. Now let's look at rights of data principals. How do we empower? How have we empowered the citizens? They have rights like they can ask for information, what data a particular fiduciary or a website or an app holds, uh, or for that matter, any government body holds. In their database, they can ask them to update their data, erase their data, stop an activity. All these rights have been given to data principal, and there, if a request is given by them, then within 90 days, a grievance has to be also resolved. They have a right to nominate also, so they can nominate, just like you have a will, and you can, after a particular person's death, the assets of that particular person devolve to other heirs. In a similar way, right to nominate, if a person dies, then the digital assets of, or the personal data, digitized personal data details, can be accessed by the particular person who's nominated. So very interestingly, that is also another aspect which is being highlighted. Now, a right of data principal to correct an erasure of personal data. They have separate sections under the law, and interestingly, one can also ask for a complete erasure of data. Now, government many times needs a lot of data for research and for also legal compliance. For example, data may be needed for 7 year period or a 5 year period. If you recall, MIT has its own circular, its own notifications, which requires 5 years of data retention in case a VPN provider is giving data services or otherwise. Those kind of norms, plus the government itself may require a data for research or study. The notice in that record needs to contain that particular ground, so that if there is a complete erasure of data, certain minimized data which is required to fulfill that legal role or that legitimate use is highlighted there. So a data principal can ask for a, if they have a grievance, they can ask for the resolution of the same, and the law again provides for that, and right to nominate, as we already mentioned. Duties. It's only not about rights, it's also about duties. So, in order to curb these cyber frauds and other problems, data breaches, the law also requires them not to impersonate another person. So we know the IT law has clear section 66CD on cheating by impersonation, prohibiting also identity theft. Likewise, the DPDP law mirrors the same requirement by putting in duties not to impersonate, not to suppress important information, and register any false complaints and give authentic information. Other key provisions include transfer of personal data outside India. Now there will be countries blacklisted, which will be very clear that these countries we can't send data to. This is something which we find also, adequacy of data protection also highlighted in the GDPR regime, where there are other ways like SCC contractual clauses or adequacy requirements to be fulfilled before data travels outside EU. So likewise, in India, we will have soon a blacklisted list of countries where the data cannot flow. In addition to that, there will be certain provisions of other laws which will influence this data transfer. For example, RBI has its own set of laws which may allow or may not allow certain sensitive data to travel outside India. Coming to exemptions, now there will be, I think you'll agree with me, there will be certain provisions where one has to do away with consent. What could be those scenarios? I mentioned a few earlier, like if there is a judicial or a quasi judicial function by an authority or a tribunal or a court for processing, data is required for processing that. That's something that should not require consent. If one is to enforce a legal right or a claim, then it should not require a particular person's consent. Processing of data principles, data outside the territory of India, where there is a contract entered by any person, with a person outside India, that this other law will apply, you know. So there would be different scenarios in business, but if wherever, at the bottom line is, wherever Indians' data is involved, they will have to comply with DPDP, whether in India it's processed or it's processed outside India. Detection or prevention or investigation, these are again certain areas which will require no consent of the particular person to process information. And likewise for legitimate use, if a voluntary disclosure is there by a data principal. I'll give an example. You go to a shopping mall and there is a particular, shop which requires an invoice to be sent on a particular person's mobile number, and the person voluntarily likes to give his own phone number. It's a voluntary disclosure. He's agreed to getting the invoice and also processing of his phone number in the database. Now you can choose to say no, but there are not many people who would probably exercise that right. Then there would be certain other legitimate uses. For example, performing a function under the law. If a law legal compliance is required, there is a medical emergency, would not require a particular person's consent in that scenario. There's a threat to public health. There is a disaster which requires relief to be given to the victims. So obviously, such scenarios don't require consent. In a nutshell, we look at penalties. They are very steep, goes up to 250 crores, and you can see how it increases. Even it's about 50 crores in case of breach of any provisions of the act, 10,000 if there's a breach of duty by the data principal, and in case no notice is given uh, by the data fiduciary, again 200 crores, and handling of children data, they ignore the provisions of law, compliance is ignored, again up to 200 crores of breach. So if a particular entity fails to put in place reasonable security safeguards, goes up to 250 crores. So this sets our background for what the DPDP ecosystem looks like and what was the intention behind creation. But how do we operationalize it? I'll just pause here for a minute, and Jagdish ji, if you would let me know if I'm all right with the speed, or would you like me to slow down, or is it all right? I think it looks fine. So far, so good.
It looks fine, ma'am. It is going
Yes,
on. No
very
issues.
well.
Thank you.
So, in any case, we will be taking questions at the end of this whole discussion. But feel free to pen down those in your, and you can discuss them in the end in the chat box. We can have them, or you can raise your hands. So, let's look at how the rules have helped in implementing the law. Now, on 14 November, when the DPDP rules were notified, this has a phased manner of, implementation. Now, when we look at rules 1 to 17 through 21, these come into effect immediately upon notification, but the requirements of notice, putting in place a consent manager, all those will happen later in a 18-month period in a phased compliance. This whole framework, in if you look at the rules, also focus on minimize data requirement, purpose limitation, transparency, storage limitations, security safeguards, and accountability, basically enhancing the transparency in how data is collected and handled. Now, rule 4 will become operational after 1 year, 3, 5, and 16, and 22, 23 after 18 months of transition. Now, all these data, breach notifications, data retention requirements, erasure timelines, all these aspects will be coming into play in a phased manner as per the transitions and the manner in which different provisions will come into play after 18 months of transition. Coming to relevant rules, sneak shot at Rule 3, for example. Now, this data fiduciary will have to give a notice. We just discussed that. So, they have to give an itemized list of what exactly is being collected. For example, if there are 5 things, mention those 5 things. What is the purpose? Mention specifically the purpose. And if the data principal wants to withdraw the consent, mention the person who he can write to or she can write to. So the name of the person, the email ID, the phone number could also be mentioned, or a link where they could fill up the form. Rule 4, what are the exact eligibility requirements of a particular consent manager? Who will be this independent entity? That is mentioned in Rule 4, and there has a schedule. There's a schedule which mentions that the financial robustness of the particular person, this entity, the years of standing, the reasonable security practices which they have to deploy to be a consent manager. All those are mentioned in the schedule. Rule 5 mentions processing of personal data for subsidies and services. So whenever those data have been taken, standards of the same have to be, they're mentioned in second schedule, and it includes if government wants to give them any services, if they've availed services as subsidies in a particular scheme, government can again ask them for availing another scheme if they have already given their data. And there's a whole process through which they can basically process that personal data for any subsidies or availing of services, which is also very clearly called out by the rules. Now, look at security safeguards. There is another rule for that. Rule 6 talks about mandatory use of appropriate technical organizational measures. So, unlike our SPDI rules, doesn't mention any ISO certification, but so far a lot of companies have been availing, like having this certification ISO 27001, And if there are AI systems being used, then 42001 is an ISO certification which will be deployed. Any breach notifications have to be given to the data principal as well as the board. This is different from GDPR, where only serious violations have to be informed to the data principals. Data retention rules. If there is a data which is to be erased by a fiduciary, there has to be a 48-hour prior warning given to the data principal. Minimum 1 year of retention of traffic logs. And there are some specific categories of data. They are mentioned under third schedule of even entities. For example, if it's a social media company or if it's a gaming portal, the personal data has to be erased if the user doesn't engage within a specified time. For example, it could be 3 years. So, if this e-commerce platform has not been used by a particular user, then that data can be erased with a prior notice of 48 hours if the 3 years time has been, has expired. So, all these are interesting, ways in which the intent of safeguarding data has been, implemented by the new rules. Rule 9 requires a data fiduciary to publish the contact details of its data protection officer or another reasonable, like responsible person in this regard. And any children and, for example, data of disabled users, the fiduciaries have to obtain verifiable parental or legal guardian consent. Significant data fiduciaries will be conducting data impact assessments and independent audits and submitting it to the board. Rule 14 requires data fiduciaries and consent managers to publish data on how the data principals can exercise their rights and submit their requests. And Rules 17 to 21 cover the structure and functioning of the Data Protection Board. Now, the central government will set up a search and selection committees for the chairperson and members made up of senior officials and domain experts. Now, this process, I also saw that it's been reported that is already underway, and the ministry is already, taking steps to identify and search for the selection of the data protection board, who will be the chairperson and the members. Now, the appointees are expected to have expertise in areas like law, data governance, and technology or regulation, and the board will function as a digital office. This is something similar to one can see in the grievance appellate committees, which are already functional. After the grievance redressal officer, the appeals go to any decisions of the grievance redressal officer. If you're not happy with that, that can be challenged with the grievance appellate committees, which are again in the Ministry of IT, a digitized office. Now, this basically explains the way in which the institution will function and how the enforcement of the law will be operationalized. Under Rule 22, you see, appeals against the Data Protection Board's orders would go to the Appellate Tribunal, which is the TDSAT. Hmm? And that also operates as a digital office. And now here they have a hybrid mode also, the TDSAT. And in this 23 rule, for example, the government basically, it gives the powers to preserve government's broad powers to call for information. So any information which the government requires from data fiduciaries and intermediaries, that government is already empowered by the rules. The notified DPDP rules convert this Act's broad principles into real time implementation pathways, how this will be actually achieved. Now, looking at the first schedule, part A, consent manager registration, there are conditions, as I mentioned. Now we are in the schedules. If we look at the consent manager role, the company has to have a strong financial position of net worth not less than 2 crore rupees, and directors, senior management have to be persons with a good credible track record. Then the operations have to be in the interest of data principles. Independent certifications have to be there that it meets the board's prescribed data protection standards, 9 conditions have been outlined. So you can see that adequate capital structure or memorandum and articles ensuring compliance are some of the key conditions required to be met with. The obligations of consent managers, again, when we look at first schedule part B, they enable data principals to give, manage, and review, withdraw consent for processing of personal data by data fiduciaries through their platform. So it's like a platform basically which will exercise the rights. Let me give you an example. If a particular data principal has an account, a bank account with a particular bank, and the data principal wants to give consent to open a new account with another bank, that another bank can actually take that consent through this platform. The data principal can allow that through the consent manager, which is this platform. So this platform enables the collection of this data and with by the new bank through the older bank. So if they're all on that sync together, that data can actually be taken. The interesting part is the consent manager is not supposed to see what data is there inside. So encrypted format should be there, which in the case of, for example, digital signatures, or we can see other ways of encryption or redaction of data that can be achieved through new tools and technologies. The consent managers have to ensure the data which is passed on is not transparent or visible to them. So that's an interesting way of looking at this whole privacy, data privacy, how it's being achieved. Now, the records have to be maintained for at least 7 years. What data they have shared with whom, on behalf of the data principal, what data they have updated, or whatever transactions have happened. 7 years of logs have to be maintained. 13 obligations, and including implementing security safeguards and avoiding conflicts of interest with data fiduciaries and other transparency obligations. So all these have been mentioned in the schedule. Coming to the safeguards and breach notifications, if you look at the security safeguards, what those appropriate technical organizational measures will be is yet to see, but industry norms, have to be followed. One of the ISOs I mentioned is 27001, but there may be more. However, the law doesn't mention any particular standard that would be deemed compliance, as in the earlier situation, which used to be. So, in this way, the technologies which allow facilitate encryption, redaction are in the focus at this point. And I've seen many companies, recently spoke at the Economic Times conference in Goa, the annual conclave, where I addressed 450 CISOs, trained them on the DPDP requirements, and we looked at various new tools and technologies by both by government sector and private stakeholders who have created these, and they're really embedded within the systems or the software. For example, if there's an email which is sensitive, contains sensitive personal data or a database of users or citizens, that if it is to be shared, there will be a classification by the email system itself to say this is a red flag, this is a green flag, this needs this kind of handling, and automatically implements that process on it. For example, if it's a financial data, that financial data will be masked, or it will be redacted, or you can say encrypted, and then only sent for a lawful purpose, of course. So situations like we used to see DLP softwares and all, but with DPDP compliance, these embedded privacy by design systems are really in demand at this point, because they have a to some extent an automated DPDP compliance. So these are being implemented and used in various departments. Now, security safeguards and breach notification. There is a breach notification under Rule 7. So where a personal data breach occurs, one has to inform immediately all the affected data principals, and also inform the data protection board. Then within 72 hours, give all the details of what has happened. So akin to certain compliance requirements which we already see in cases of some cyber frauds, we inform the certain, right? There's a format for that. So DPDP compliance is an additional step in case personal data breach has occurred, and this requirement is also to be met with. Data retention and deletion, and under Rule 8 with third schedule, it specifically lays down certain processing of logs to be retained for minimum 1 year. And as per third schedule, after inactivity period, 48 hours advance notification to go, and 1 year retention has to be there. And 3 years, if they have passed, and a social media platform, for example, has an account, it can ask for a deletion after giving an advance notice. And these kind of requirements have been very clearly called out by the new rules. As far as data localization is required, Rule 13 talks about that. There will be some specific data. For example, the health ministry may require certain health data to not flow out of India unless it has followed its like particular restrictions which have been mentioned, or the conditions. Likewise, financial data. So different ministries may come across with new set of rules for some sectors which require that kind of dealing, so that DPDP allows that particular regulation to function alongside the DPDP norms. Response timeline for data principal is 90 days. So if a user complains, the particular grievance has to be resolved within a period of 90 days, and this allows them to exercise their rights and submitting their requests. Right to nominate covered by 14 of the act. As I explained, the person can nominate another individual to exercise their rights in the event of a death or an incapacity. And the processing of personal data by a state, this is important. So the DPDP act allows certain legitimate uses for which the data fiduciaries, if it's a government body for example, can process personal data without need for express consent. Rule 5 we read with second schedule. It has the standards set for processing by the state and instrumentalities in order to provide subsidy, benefits, or other services. This data can be processed for issuing these subsidies and benefits, and issuing licenses, and using the platforms for any kind of benefits given to the public. In this scenario, consent may not be required, where the data processing has to be lawful and it is limited to a specific purpose to give that benefit to the citizens. And data collected is not more than necessary and kept accurate with reasonable security safeguards. And they have to for example, there would be some standards which the government will issue, so it has to be in compliance with those standards and norms. Any data transfers outside India, they have to be subjected to requirements by the central government through general or special orders. So the transfer will only be in compliance of the same, and data localization norms will also have to be adhered with. Blacklisted companies will be looked into, which ones you can't send data to. So all these are aspects which come in the data transfer outside India, along with the sectoral norms which will also have to be kept in mind. Now, so if we see data protection board, the establishment, as I said, is a digitized, office with 4 members, and headquarters will be at a location which government will specify. Powers, functions, inquiry timelines all have been given, but a 6-month time window generally. They will resolve these complaints. Appeals go to the TD SAT within the 60-day limitation period as per limitation law. If we look at the remaining schedules under the DPDP, there are different schedules. For example, there is a schedule which, for example, there is the fifth schedule, which has the chairperson members' compensation provided. The sixth schedule talks about the board officers' employees' terms. Fourth schedule exempts clinical establishments, or the state laws, education institutions, including schools, universities, for specific purposes like disaster management or medical emergencies. So, various aspects are being covered by different schedules. The deletion timelines in the third schedule. Then there is sixth schedule. Then there is seventh schedule for purposes for which the data can be called for, from different intermediaries for protecting sovereignty of India or other, dire like situations, serious situations of security of state. So all these schedules talk about different aspects, but what is important is that they allow implementation with enough transparency. So that's important, and that's what allows one to have, deal with any kind of arbitrariness that is deleted through these steps. How the DPDP rules align with DPDP Act. So, in a nutshell, I'm just trying to now wrap up the whole discussion by putting our conclusions in place, that, for example, the DPDP rules came about, but how they will operationalize the act is through various provisions, like, for example, a notice requirement. A notice requirement one can deal with when we read with the rules how this will be achieved. So one has to inform the people that these are the exact things which are required to be given or are being collected. So it allows transparency in that regard. How the informed consent has to be taken. So if you're clicking on an I agree button, you're reading the contents of the notice, and that's an express action, affirmative action of giving consent. And therefore, whenever these law is created, gives a basic framework, the rules help us in achieving that through an example, either through illustrations or through concrete steps that can be utilized to achieve that goal. So, another example, when we're saying you have to implement appropriate technical organizational measures to protect data, that's the law. Okay, the act says so. But how? So the rule explains that. Seven specific security requirements to be met with. So it is not something ambiguous. What is, after all, technological organizational measure? So any ISO, for example, which involves and encompasses encryption, access control, logging, monitoring, continuity measures, and so on and so forth, these criteria will actually fulfill the rule, unless there is a specific ISO given, which is not given in this particular law. So in this way, it fills in the blanks, I would say. Section 686, for example, has a notification has to be given to affected data principals if there is a breach. So how does Rule 7 operationalize this? It says that this notification has to be immediate, without delay, and then give detailed information about the breach, the nature, extent, timing, consequence. This also explains how that will have to be achieved. So one liner saying there's a personal data breach at our department doesn't suffice. All this has to be also mentioned in the same. So that's what the rules do. Now they bring clarity to the whole objective of the act, basically. Inform within 72 hours of the breach. So this DPDP rules further, when it talks about erasure, unless retention is necessary, you have to erase. So then the rules also say the timelines in which the schedule mentions that you have to erase. For example, if it's a gaming platform with 50 lakh users, you know, there's a timeline. You have to erase the data in, let's say, after a 3 year period expires. So coming to section 9, protecting children data. Yeah, so there is to be a verifiable parental consent. How does parent give the consent? There are illustrations in the law for the same. For example, if a parent already has a social media account, they can allow the child to also have an account through their consent, and a verification through that platform. So that's another way. Then, how the processes of verification will happen, whether it will be through an ID verification or something that can be worked out, like a DigiLocker service is being used, like we do verification through Aadhaar or a DigiLocker. What exactly is a process. It could be, any identification also of the parental account in that platform. That's one of the ways. So those have been explained in the rules. And then comes section 10. The central government will notify who will be the significant data fiduciaries based on the factors like volume, sensitivity of personal data, yet to be done. So this will again be operationalized through Rule 13, because it places other additional obligations on significant data fiduciaries. So, in a nutshell, the DPDP Act, it recognizes also the need of intermediaries to help these data principals manage consent. So, consent management becomes a crucial aspect, where 9 conditions for the registration has been given in the first schedule, and then detailed, provisions of how the consent managers will function has also been provided by the rules. So, in this manner, standards for processing are also mentioned in the Rule 5, and exemptions are mentioned under Rule 17. For example, research, archiving, statistical processing, all are exempted categories, do not require express consent in this regard. Now, further, if we look at the Rule 16, second schedule, it basically means that this exemption is there. There are standards which will allow processing. For example, they have to be a lawful purpose, a lawful manner of processing, and they have to be limited to research, archiving, or statistical purpose if the data collection is for that same purpose, and accurate data has to be maintained. So, in this manner, the rules have actually supplemented the intent of the law. There will be still gray areas, and there are questions. I'm sure there are questions that you have in your mind, but let's just conclude this session, and discuss what are the key issues that you'd like to understand in this ecosystem, and how you would want, to implement the various provisions of the law, and where, you find that needs clarity. So let's look at that, and I'll just stop share screen at this point and go back to our main screen.
Thank you, ma'am, for your wonderful and enlightening session. I think there are a number of questions which are already lined up for you. So
Mm-hmm.
I'll be reading some of the questions.
Please.
Maybe you can just give them the kind of responses, ma'am. So, do data principals have the right to nominate someone to exercise their rights in case of death or incapacity?
Yes, of course, they have a right under the law, and they can do so. I was explaining that even, they can manage consent on behalf of the data principal after the person is no more. I mean, obviously, if they've been nominated, they can exercise rights in respect of that data. That's absolutely yes, as an answer. Yeah.
Oh, okay. Thank you, ma'am. And just want to know whether publishing the SAR by ECI is a violation of DPDP. And I am asking this because I have submitted the form to ECI for inclusion of my name in the voter list, but not given the authority to ECI to publish it online. At present, my details, including the address, is publicly available. Whether anyone can see, I can see the personal details of all the voters in SAR.
Okay, so any data which you're sharing with a particular authority, I'll give you as an example, a benchmark, what basically the authorities are doing. If they are collecting it for, purposes of providing a service, then in that situation, they have to put it in the notice and consent requirement that they will be publishing and collecting the data and using it for this purpose and publishing it as well. If it is for a legal compliance, even in the cases of, criminal cases, for example, FIRs are also published online. There are cases where it may not be, because the situation, that particular case may require that kind of a dealing. So whether it's for legal compliance or legal purposes and may or may not require a consent is also a question which has to be seen. So it really depends on facts of every case whether they can publish without the need of a consent or without taking a consent in a given scenario, right?
Okay, ma'am. Thank you, ma'am. Thank you, ma'am. Can CDEC or any government body, which is autonomous or PSU, become a consent manager? See, someone is asking, ma'am.
Can would you please repeat the question?
Can CDEC or
Hmm.
any government body, government body in the sense like which is autonomous or PSU, can be become a consent manager?
Now that eligibility requirements have to be met with, they have to be independent. That's what is written so that there is no bias. Whether they would be considered or not, we have to go with the eligibility norms only. And unless we can show that they're entirely independent, that may be a question mark.
Okay, ma'am. Okay, ma'am.
Mm.
Yes, I think this is one more question. A few more
Hmm.
questions are there, ma'am. If someone uses a malware application that steals the personal data as well as the government data, are there rules under the DPDP Act to apply? Or what about a user who knowingly uses such as an application?
If a person is using a malware to infect a system, maybe, or and
Yeah,
to uh,
infect the
create a
system
data
as
breach,
well as the
basically to
correct,
cause
ma'am.
a data breach to happen.
Correct,
It
ma'am.
is
Correct.
it is something which is commission of a cyber crime because that's under the IT law also. If we see hacking, for example, computer-based offenses, it's punishable with the offense of up to 3 years of imprisonment, fine or more, because data accessed without authority
Yes.
is something which is a breach of the system, and it could also be a breach of a protected system, which in which case it could also amount to cyber terrorism under 66F, depending on what the data is, right?
Okay, ma'am. Okay, ma'am.
Yeah.
Good, ma'am. And next question, ma'am. What needs to be done at an organizational level if it is
Hmm.
collects the digital personal data of employees, consumers, vendors, visitors, or guests, etc.?
Yes. So as I was explaining, the DPDP law is there. Now act as there, rules are there. Now the question is that most departments and most private institutions are trying to work out a strategy by which they are able to comply with the law. In order to do that, first is the legal scrutiny. When we say legal scrutiny, we mean that we see how the department is functioning at this present point of time. Number one, what data are they collecting from the citizens, or what data they hold of their employees, for example, and what is the personal sensitive data included. For example, it could be financial data, it could also be health data, depending on what the department works with. So if they have that kind of data, so you have to classify the data in the first place, and then see whether the notice requirement that is required by the law, are they taking consent from the users, have they taken consent from their employees, for instance, or from the users. So if that privacy policy or the consent is not as per the law, that has to be changed, that has to be reviewed. So that has to be done, plus the agreements with the vendors. If there's say a software that you're using, or a server you're using, what is the data, they become a data processor because you're storing data maybe in a server. So how they are going to be bound by the DPDP law, you are actually responsible for their compliance also on their part, because you're giving them the data for processing. So the agreement has to be again looked at, reviewed by expert legally. Unless you do that, the DPDP compliance documentation part as well as operationalization will not be possible. So second comes the operations. So you review the operations. For example, I'll just give you a very simple example. A department collects data, or a private institution collects the data which doesn't need to be collected. For example, I was advising one of the international NGOs, and they were collecting data of citizens, for example, beneficiaries who would be benefited by their social service policies and research projects. So what was happening was they were collecting, even for example, their religious faith, or their say any health record related data. which was not even required for giving a particular social service, in that project. So we automatically did a red flag and said that this is something which you should not collect under DPDP law now that the law is in place. So this way we revise the way in which they operate also. This is just one of the very simple examples, but there could be more issues which need to be changed in what kind of data is collected, how it is preserved, and how it can be shared. So all this has to be looked into in a phased manner. First, you look at the documentation part. Second, you look at the operationalization part.
Okay, great. And ma'am, can share the patent PIIs, like personal identifiable information, to the state stakeholders in the context of healthcare. If they ask related to the personal information like phone number, name, etc. Just I think the question is incomplete. It looks like I
What
think
I
it is.
is whether it will be covered by DPDP law. It will be covered by DPDP law, and for example, there are apps which allow you to monitor health. These days, there are smart beds which allow a lot of health record or data. For example, BP of a particular patient. A patient is on the bed, and that data is going, across the hospital or to various departments to monitor it. That kind of data is very sensitive. So obviously, any leave aside the email ID and phone number. I mean, that is also personal data, but such sensitive health record data will have to have more encryption and more scrutiny in how it is collected and shared and preserved.
Okay, thank you, ma'am. And what to be provided in consent and how frequently to take the consent from the users, ma'am.
Okay, very important question, because I feel that old consent forms may not hold good today. So if earlier, before DPDP has come into being, consent was not taken for some data collection or and publication. For example, there is a company which collects data and puts some data on a social media platform of theirs to publish the work that they're doing in an area. That photographs of those citizens, maybe earlier was that consent was not taken, but now if they're doing that, they have to give a notice and consent requirement. If that data is still there on online, they can now also give a new consent form for allowing them to publish their data. But it's a caution sign. If they haven't taken consent earlier, it's better to have a fresh consent from them.
Oh, okay, ma'am. Okay, ma'am. Thank you, ma'am. And I think people are asking about the PPT that we'll get back to you.
Sure.
What is the difference between a consent manager and a consent management framework?
Interesting. So, consent manager is the independent body that will be monitoring and helping the data principal and fiduciary take a consent from the data principal. Uh, that data, like consent manager, has to be registered with the board. Some entities may even choose not to have a consent manager because they have very limited people who they're catering to. In that case, they can repute a particular person within their organization, like a grievance officer. They can have a consent uh, person who would manage the consent on their behalf. But if it's a big entity which has a big department and caters to a lot of people, that may not be possible by a single person. So the consent manager's role becomes important. Then that independent platform will be engaged by that data principal to manage the consent. Second question was consent management framework. Framework will entail how the consent manager will exercise its functions, which means that the data consent manager will be actually how they will collect the data, how they will be preserving it in an encrypted mode, and how another data fiduciary can contact them to take that data from them on behalf of the data principal. So, how they will function is what the data consent manager data framework will really function with. Yeah, or operate, basically how it will operate. Yeah.
Okay. Thank you, ma'am. Thank you, ma'am. Can data be transferred outside India under DPDP Act?
Yes, it can be, but they will be subject to restrictions, and also certain countries will be blacklisted, as I said in the during the session, and sectoral norms will have to be looked into, and data protection norms they have to be adhered to. Yeah.
Thank you, ma'am. I think few more questions are there. With your kind permission, shall we take those questions, ma'am?
Yes, if there are just one or two, then we can wrap up the session, and maybe if there are a few more, you can maybe send them over to me on an email, and I will answer them.
Okay, ma'am. Sure, ma'am. Does the consent manager and the data fiduciary will be from the government department or private companies?
Data fiduciary, please repeat your question.
Does the consent manager and data fiduciary will be from the government department or from private companies, ma'am?
Data fiduciary will be any entity which is collecting information, any entity. And
Correct.
consent manager is separate. It is somebody which is a independent platform which will manage consent of a data principal and how that data will be shared with a data fiduciary. So an entity may even choose not to have a consent manager and simply depute a person in their organization to handle that.
Okay, ma'am. Okay, ma'am. Thank you, ma'am. And what about NGO collecting the data from their membership and are published online or hard format? Is it legal?
If it is published online, the notice has to say so that they are allowing, taking the permission for the same. Without permission, they cannot publish any data like that on their platform. Even from their sponsors, if they are sharing any data of beneficiaries or donor data, all these things, if they are publishing anywhere or sharing anywhere, then the adequate notice and consent requirements have to be met with.
Okay, ma'am. We'll take another two more questions, ma'am, and after that we will conclude, ma'am.
All right.
And thank you, ma'am. And during the data sharing between two software applications, if the personal data is shared with other entity in an encrypted format, in an encrypted format, in that case, who will be responsible for the data breach in case of the data theft happens? And how to ensure the other entity also follows the DPDP principles, since the other entity is not the primary organization.
Okay, so they become the processor, the other entity which is processing the information. So that will be achieved through having an airtight contract with them. So that from our side at least we have ensured that we have given them a due notice that you have to abide by the DPDP norms. If they still fail to act accordingly, they can be penalized for it, and not the main entity which is the data fiduciary. So this way it can be achieved like a back-to-back contract. As far as liability is concerned, if the two software companies, for example, if they're interacting with each other and processing some personal data, then they have to put in place adequate security norms to protect data, for example, through encryption. Now, if there's a third party attack which happens despite these measures, then certainly at least these companies can, showcase the fact that provide evidence that they have taken due measures required by the DPDP law. Because something like data breaches, there is no foolproof security mechanism with the best of security parameters. Still there will be some 1% way of loophole which will be there because of the new kind of attacks which are happening today in the cyberspace. So at least if you're able to show due diligence has been met with, then that burden of proof is actually lifted to a great extent, because then at least it will not be intentional. And even if a data breach occurs and you've complied with the information to the board and other requirements, and show that you have put in place adequate measures despite that it has happened, then to a great extent you have you've basically complied with your obligations and your part.
Thank you, ma'am. I think last question we
Hmm.
will take, ma'am. And we are sorry, like all the other members, like who are asking. in the interest of the madam's time, like we have to, conclude the session. Madam has to go to her,
Yes.
a court.
I have another meeting. Actually, there is another meeting, but
Sorry, sorry.
I'm so glad that there are so many questions. That means that the session has been successful, because if there are questions, everyone's been thinking, everyone's been hearing, and thinking about what could be the loopholes in the whole scenario. I'm glad about this. And what I would say is that this is just one of these sessions, and I keep having various sessions, and also advise various ministries of the government, including the Defense Ministry, IT, and I've had sessions with Law Ministry and MHA and others. So if there is any query or any project at any point of time, I have helped a lot of, given my expertise and contributions there. So if there's any project which requires this kind of, scrutiny, legal assistance, I'll be very happy to, provide my support on that. Yeah.
Thank you, ma'am. And we will take the last question, ma'am. And who will be the responsible for data protection if the data is hosted in a state data center? The department or the developer who host, manage, update, and own data, or SDC? What is the responsibility of each stakeholder?
Well,
Yeah, that is.
now if there is a data center, obviously they also have a contract with the state, so if it's like a private data center for that particular department, or government data center, depends on the roles and responsibilities which they have agreed to under their own contracts. So therefore it becomes very important, in order to see that you have fulfilled your role and you have put in adequate safeguards to minimize your liability, or to do away with your liability to a great extent, because you've complied with all the norms required. One has to look at the agreements and what responsibilities lie, because a data fiduciary is equally responsible as a data processor. So if the data center is being used, they are in the processor capacity, and their agreement with the main fiduciary is the main document which will really throw more light on this. Yeah.
I think, ma'am, I think one person from Rajesh Suri, who is from Setin. I
Mm-hmm.
think he raised his hand, ma'am, and I made
Please,
him as a panelist. Yeah,
please,
over to Rajesh Suri
please.
for your question, sir. You can,
Just
enable
want
the
to
speaker.
intervene. Just want to intervene in this last question. Basically, in my view, the law of the land will override whatever the contractual obligations are there.
Oh, of course that will, because that is the applicable law.
Yeah,
One has to abide by. That
but
is
yeah,
absolutely correct. However, whenever there
because
is
it is
an,
the responsibility of the data fiduciary. It
yes,
is that ki they are just renting and taking space from the data center. But
yes, but
responsibility lies with the data fiduciary.
absolutely, because the data fiduciary is the main person, I would say, entity which is taking the notice and consent requirements
Yeah.
under DPDP law. They have to ensure that the data center which they are taking has also put in place adequate security measures which will ensure the safety of the data which is being stored there. So that goes without saying. They have to be equally, I
Thanks,
would
sir.
say, obligated to maintain that data. So I agree with you on that. Absolutely, they are also responsible. And in fact, it's the main responsibilities of the data fiduciary, and
Yeah,
therefore they must ensure that the contract, the agreement which they have, also showcases the same.
yeah,
It resonates the same, obligation. And processor should not go scot free, saying that I had put in place some measures, but not as per DPDP. That should not be there. It should, in fact, specify there that I have complied with the DPDP norms as a data center, and therefore, data fiduciary can show that they have checked their certificates, or they were ensured that the data center is fully equipped to handle that.
yeah. Thanks, man.
Thank you, ma'am. Thank you, ma'am.
My
And
pleasure.
thank you, ma'am, for all the patiently responding all the queries and enlightening session. And Vyas sir is also joined from Ministry of Electronics and IT, Government of India. He is in
Namaskar,
the
sir, and namaskar, Rajeshri. I think it is a wonderful way of opportunity to interact with you here as well on this platform. And I always look forward to sessions with MIT and other government departments, because we work seamlessly across various ministries on various projects, and having this convergence is something that is a need of the hour. So I'm very happy that you were able to join the session today. And if you have any questions or any way in which I could be of assistance, I'll be more than happy.
No, no, I'm really grateful that you could find some time to spare on this important topic. In fact, I think 2 years back, before we were in the process of formulating the rules and all, we invited you, and that was one of the most viewed and well-received session. So we are really happy that you are again back, and now once the rules were notified in November last year, so
Yes,
you have got more substance to actually tell to the audience that how it will be actually implemented. And the
yes,
range of questions which the people have asked itself proves that this particular session, of course, as you have mentioned rightly, that has gone down very well, and people have been able to understand some of the things, and some more queries are there. But that also, I mean, adds to the point that a lot of capacity building in this area needs to be done now, because now we have only 18 months to go before, I mean, this not the, I mean, 18 months, maybe only 15 months now. So to actually see this on the ground. So we will have to do a lot of efforts in capacity building, and we'll seek your help time and again
certainly.
whenever possible.
Yes,
So
with the ISEA also, I've been doing a lot of these sessions, and with the ICA, I think Jagdish is very active in it, and I've always tried to give her support. And Mighty is doing wonderful work, and with your leadership there, and I'm sure different departments, there would be other officers from the various departments today. They are going to be dealing with the DPDP in
that's so.
everyday balance. So I'll be more than happy to support any of your project requirements or otherwise, looking at the rules and how they will be implemented.
Right, and thank you so much, and really grateful for you giving this lecture and share your
Thank
point
you
of
so
view.
much. I'll take your leave now, and
Thank you.
I look forward to more sessions and interaction. Thank you very much for everyone for joining today, and Jai Hind in the end. Yeah.
Thank you. Thank
Thank you, ma'am. Thank you so much,
Thank you.
ma'am, and thank you so much, sir, for joining this session and enlightening
Yes.
our users. Thank you,
Yes.
ma'am. Thank you so much, ma'am. Thank you
Thank
so much,
you.
sir.
Thank you so much.
Yeah, dear sir, ma'am, like we were concluding, and next month, like we will be coming up with one more session as part of this Cyber Jagrata Divas. And we also request to visit our portal, like Stay Safe Online, for quizzes and pledges and recent competitions which we have announced to participate. Or please spread this information with your near and dear in your family, your organization, and all. Thank you, Vyas sir, for joining and enlightening us on this aspect.
Thank you. Thank you. Bye bye. Thank you.
Thank you, sir. Thank you, sir. Yeah, we have done from our side, like the participants may leave the platform now. Thank you. Thank you so much, one and all.